Now today we are going to start this again new topic, charge and criminal trial. We know the criminal trials there are four kinds of trial. That's what we are going to discuss today. So we'll start with charge provisions and then we'll followed by different forms of trial. So that's our area of discussions today, charge and criminal trial. And in criminal trial, you are aware that there are four kinds of trials within criminal justice system. So we call session trial, then warrant trial, summon trial, summary trial, and all these four kinds of trial will look into one by one in today's class. Okay, so let we begin on charge and other criminal trial. When we talk about the charge, remember in the CRPC, it was from 211 to 224. That's the broad area of charge. The same thing has been incorporated in BNSS from 234 to 247. Now, when we look at this chapter on the charge, you don't find much change from the CRPC to BNSS. Almost similar provisions are there, so there is not much changes in it. But then when we look at this entire charge provisions, you will find there are two categories of things are there. So the initial 7 sections are on form of charge, and then remaining 7 sections are we call joinder of charges. Now, what is these two forms? Remember in the our initial class when we discuss about the definition which is given in section 2 of BNSS, one of the word which is defined there is charge, but you don't find much very detailed definition in section 2. Section 2 definition of charge is only says charge with one head, charge more than one head. Implies that the definition in the real sense classify charge into two categories: charge with one head, charge with more than one head. What that it implies? Why is charge with one head or more charge with more than one head? Why we have charge? The idea is charge of the idea relating to charge is that every single accused person has right to fair trial. One of the essential component of fair trial is that accused must know what are the allegations brought against him or her. Now, the before charge stage, all the allegation might be brought by the police. So FIR is there, they have done investigation, they have submit police report in the form of charge sheet, but this is not formal allegations brought by the court. So the first formal allegations brought by the court is in the form of charge. So what the charge do? Charge make it very clear to the accused that look, now you are being tried for committing these kinds of act. So accused may have committed multiple things at one go. So if an accused has committed 3 distinct offenses, there might be some circumstances when court may say that, okay, firstly, for doing this, you have charged under this section. Secondly, for doing this on such and such day, such and such time, you are charged with one head. At one place, you can say everything. There may be options where you have a multiple head in which the charge can be framed. Who framed the charge? It is court. So the charge is first formal allegations brought by the court. Before the charge, there is no formal allegation brought by the judicial system. It's the police which registered FIR. Some investigation being conducted. But formal allegations from the court, it start from the charge. So in that way, how the charge should be drafted, what should be things there in the charge, what happened, say for example, where only simply saying offenses is not enough. So for example, there might be allegations against someone, say in I can say in the list of all the students, first name is Altamas. So there's allegations against Altamas that Altamas appear as a witness in the court and he did make false statement. So he is being prosecuted for perjury or making false statement. Now, if the court framed the charge that Mr. Altamas, you on such and such day in such and such court make false statement, accordingly you are being prosecuted under such and such sections of BNS. Now, is it enough to give Altamas idea that what offense he committed? Answer is no. Altamas might during evidences, he might have 5-page statement. And the all 5-page statement could not be wrong statement or false statement. So here, saying that you have committed perjury, you have committed some false statement. So there may be some circumstances where only simply saying that you have committed this offense is not enough. Here you have to say, the court has to say that which of your statement is really wrong, false, and accordingly you are being prosecuted. So there might be some circumstances where simply words is not enough. There might be some circumstances where the law has used some kinds of offense in specific terminology. So whatever the terminology law has used, that has need to be used in the charge. So when you look at 234 to 240, they all talk about the content of the charge, and then 239, which was earlier 216, about the court power to alter the charge. So very wide power. Can court alter the charge? Answer yes. Court can alter the charge at any point of time before pronouncement of judgment. So we'll look at the first part, which is talking about the form of the charge. Then why the second part, joinder of charges? Now, when we look at this entire chapter on joinder of charges, you will find two categories of things are there. What are those two categories? There may be some circumstances when different offenders can be charged together. So say we have a terrorist attack in Kashmir just 3 days ago. Might be that plan has been done in some other places, someone has done some other act. So 10 other people are involved which acted, or 100 people involved acted in the different places. And then ultimately it was executed in Kashmir in that particular place. Now, all those 100 people who are involved in the processes, they can be charged together. So what we call joinder of charges. So one component of joinders are when different persons can join together. Law permit it. The second concept of joinder could be when different offenses can charge together. So a person can be framed charge against him for committing different offenses. That's also the joinder of offenses. So joinder of person, joinder of offenses, both you will find in this part of the act. So that's basically the concept of framing charge. Very important for any criminal trial or serious criminal trial. The charge is an essential component. Now, in all criminal cases, the charge is not framed. Charge is being framed in two categories of trial, in session trial and warrant trial. In summon trial and summary trial, we follow some alternative process which is called plea. So which is similar, where in gist the allegations being made to the accused, because this is the ways in which we inform the accused that look, these are the allegations brought against you, and accordingly you are being charged for committing these offenses. So that's what the law basically, charge provision is talking is there under the law. Now, so first we start section 234, which talk about content of charge. Now, some of the, because a large number of sections, I'll skip something, I'll not go in detail. So it's your, I requested all of you to go through the provisions and come for this lecture so that it will be clear to you about content of charge. So every charge shall state the offense with which the accused is charged. So whatever the offense he committed, that must mention there. if the law which creates the offense gives it a specific name, so some offense being named as a forgery or some other thing, cheating, rape, whatever name the law has used, that name should be used. If the law has not given any name, then at least you have to give such much information which make it very clear for the accused to understand what are the nature of allegations brought against that accused. The law and section of the law against which the offense is said to have been committed, that also need to be mentioned in the charge. The fact that the charge made is equivalent to a statement that the every legal conditions requisite or required for constituting that charge are being fulfilled. If the accused being convicted previously, and remember, you will find in the Nyaya Sanhita or there are other legislations also, where it is consistently said, where a persons on the first time convictions, they get lesser punishment, but on subsequent convictions, they get higher punishment. So if a person is liable for higher punishment being subsequently being prosecuted, then in those circumstances, it need to be mentioned that earlier you have convicted on such and such offenses. So that also need to be mentioned under the law. You will find this illustration. I'm not going into detail of the illustrations. You can read yourself these illustrations. So law will mention specifically section in which is being committed, etc. So you'll find 4 illustrations are there. Let me read one illustration D. A charge under 219 of BNS, intentionally obstructing a sale of property offered for sale by lawful authority of a public servant. The charge should be in those words. So whatever the word, the language being made, when we frame the charge, those words need to be mentioned. Now, so for charge is concerned, as I said, it's a very important piece of document for criminal trial. From here, the really criminal trial begin. In fact, many people say, when criminal trial begin, it begins with the charge only. So in real sense, upon is arrested, FIR is done, investigation is conducted, still trial is not begin. Real criminal case has not started. It will only start after charge being framed. So VC Shukla case court says charge serve the purpose of notice or intimation to the accused, drawn up according to the specific language of the law, giving clear and unambiguous or precise notice of the nature of the accusation that the accused is called upon to meet in the course of trial. He has to defend himself. He has to bring his witnesses. And accordingly, this helps the accused that, okay, what are the allegations brought against him? And you have to give meaning to the, he can defend his cases accordingly. The next section, the first section, general principle. Next sections, particular as to time and place and persons. So when offense committed, where it is committed, which person has committed, against whom the offense being committed, all these things need to be mentioned. So charge shall contain as to time, place of the alleged offense, and the persons against whom or the thing, if in any respect of which it was committed. Someone committed theft of a gold jewelry. You have to mention that. Someone committed theft against Mr. X in a particular way. You have to mention that. 2. When the accused is charged with criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum as the case may be. So you don't require to detail so many things, but the gross, this much disappropriation of fund is being done, etc. So idea is he will understand. In some cases, like this disappropriation done in last 1 year or last 6 months, etc. So provided that the time included between the first and the last such date should not exceed within 1 year. So within 1 year, whatever happened, that should be included. So the charge purpose also in BNC Khan says that it should give meaning to it. Kalicharan case principle clarified regarding the effect of omissions to frame proper charge and to put relevant circumstances to the accused during their examination under 313. Now the number has changed. The idea is that the charge is give the indications to the accused that what kind of things for which is being tried, etc. so they can defend themselves. And if there's some kinds of omissions, etc., that will be rectified, because I said there's a provision which says charge can be altered at any point of time before pronouncement of judgment. Now, when manner of committing offense must be added or given, there might be some circumstances where only saying that you have committed theft or some X offense is not enough. As I said, perjury issues or other issues where you have to give specific information, if specific defect, how you have committed these offenses. So in those circumstances, at least that much information, that particular information of the manner in which the alleged offense was committed, as will be sufficient for that purpose. So someone did forgery, how they have done forgery, criminal misappropriations, how they have done it, that criminal misappropriation. So where sometimes you require little more information that need to given. So whole idea is that accused must understand that whatever allegations are brought against him, he must know that these are the allegations so that he can face trial accordingly. He can defend himself. So it is a very essential component of right to fair trial because he has to defend himself. You will find some illustrations given here. For example, first illustration says, A is accused of theft of certain article at a certain time and place. Charge need not set out the manner in which the theft was committed. That's good enough. A is accused of cheating B at a given time and place. Charge must set out the manner in which A cheated there, because only saying cheating is not enough. You require how the cheating is being executed. A is accused of giving false evidence at a given time and place. The charge must mention the portion of the thing which was false, because a person might have many statements. No, all statement cannot be false. So accordingly, charge must mention that this is the statement which you have made, which is false, and accordingly prosecution brought against you. A is accused of obstructing B, a public servant, in discharge of his functions at a given time and place. The charge must set out the manner in which A obstruct B in the discharge of the official functions. So there are many circumstances when only simply saying that you have obstructed the public servant is not enough. You require how you have obstructed, what thing you have done, etc. A is accused of murder of B at a given time and place. There is no requirement of giving manner in which it is being committed, because it's clear that you have committed murder of him and such time and such date. A is accused of disobeying a direction of law with intent to save B from the punishment. The charge must set out the disobedience charge and the law infringe. So basically, the whole idea is that you must give those much information which is necessary for the accused to understand the allegation which brought against that accused person. That's the necessary. Now 237. It's just explanation. Word in charge taken in the sense of law under which the offense is punishable. So if some word has been used in the charge, it will mean that it is in that sense only. So in every charge, word used in describing an offense shall be deemed to have been used in the sense attached to them respectively by the law under which such offense is punishable. Effect of error. Suppose if there is a omission in the charge, if there is a mistake in the charge, then what will happen? Now law is very clear that no error in stating either the offense or the particulars required to be stated in charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material unless the accused was in fact misled by such error. So if the accused are misled by that error or omission and it has occasions of failure of justice, so what is the requirement? If the mistake lead to the failure of justice, misled by the charge, then it might have effect. But if has no accused is not misled, then it is difficult. Suppose charge is framed that you have committed murder of Ram. Now that accused might have committed murder of two Rams in two different places in two different dates. He is not sure for which date this charge is. Then material. But if says only committed only one murder, one place, that is not material. So depending on the circumstances, the whole idea is that charge must give proper details which can inform the accused that okay, they are allegations, these are the allegations, and they can be defended in that way. But if that omission is wanted to failure of justice, then there can be issue arises, otherwise no. So here you will find few illustrations are given under the Act. For example, first illustration says A is charged under 180 of BNS, which having been in possession of counterfeit coin, having known at the time when he become possessed thereof that such coin was counterfeit, the word fraudulently being omitted in the charge. Unless it appear that A was fact misled by this omission, the error shall not regard as material. Does not make any differences by just not having that one word. A charged with cheating B and the manner in which cheated B is not set out in the charge or is set out incorrectly. Defend himself, call witnesses and give his own account of the transaction. The court may infer from this that the omission set out the manner of the cheating is not material because he understood that case. C. A is charged with cheating B and the manner in which he cheated B is not set out in the charge. There were many transactions between A and B and he had no means of knowing to which of them charge referred to. Now this is material. So depending on the situation, sometime it may be material, sometime it may not be material. Last illustration. A was charged with murdering Hyder Bucks on 20th January 2023 and Khoda Bucks who tried to arrest him for that murder on 21st January 2023. So two murder consecutively one day, one after another. When charged for the murder of Hyder Bucks, he was tried for the murder of Khoda Bucks. So the witnesses were present in his defense were witness in the case of Hyder Bucks. The court may infer from this that was misled and it was a material error. So if he is really accused being misled, then it is a material error, and that material error is always having some adverse impact on the case. Now this is very important, section 239, which says court may alter charge, and that's very important to understand that the court has power to alter charge at any point of time before pronouncement of judgment. That's what the clause 1 says. So any court may alter or add to any charge at any time before judgment is pronounced. Very wide power given to the court. Earlier it was 216, now it is in 239. But the difficulty may arise in some cases where there is an underlying requirements, then it will become difficult to alter the charge. For example, say there is a act called ITPA, Immoral Trafficking Prevention Act. And under ITPA, the cases can only be investigated by inspector or above rank officer, which called special police officer. Now the charge sheet is submitted, trial case was started only under IPC, and the charge sheet was submitted under IPC. Charge sheet is submitted by some inspector. While the trial is going on, court found that no, the ITPA should have been used, it is not used. Can court alter the charge? Answer is no. Because the underlying requirement is not fulfilled. Court has to send back for re-investigations, and then an inspector can submit the supplementary charge sheet, and then only the charge can be done. That can the court send for re-investigation? Now, when we look at, I think we have gone through this when we discussed about investigation. Now 193 clause 8 or 9, where it is categorically written that even during the trial, if something new appear and there's a prayer for investigations, court can send for investigation. It's possible under the law. Now clause 3 says, if the alteration or addition of a charge is such that proceeding immediately with the trial is not likely, in the opinion of the court, to prejudice the accused in his defense or the prosecutions in the conduct of the case, Court may, in its discretion, after such alteration or addition has been made, proceed with trial as if the alter or added charge has been original charge. That possible. If the offence stated in the alter or added charge is one for the prosecution of which previous sanction is necessary, the case shall not be proceed with until such sanction is obtained, unless sanction has been already obtained for a prosecution or on the same fact as those which the alter charge added, etc. So the charge entire process play very important role, and this alterations power is a enormous powerful provisions for the court. So in Anand Prakash case, court says principles summarize relating to object and scope of the power of the court to alter or add any charge. Test to be adopted by the court while deciding upon addition or alteration of charge and duty, and constraint on the court while exercising the power under 216. Now it is 239. 240, it talk about recall of witnesses when charge alter. So when charge is being changed, charge is being altered, then in those circumstances, if court consider that there is a need for examination of some witnesses or recall of some witnesses, court can do so. So A, what the option which the court has to recall or re-summon and examine with reference to such alteration or addition any witness who may have been examined. Unless court, for the reasons to be recorded in writing, consider that the prosecutor or the accused, as the case may be, desires to recall purpose of vexations or delay, etc. Also to call any further witness whom the court may think to be material. So that possible that when you choose to, when the court change the charge or alter the charge, then even alterations, they can call for added witnesses, or witness can be re-examined, unless court think that this re-examination is for just delay the process. Now we come to second part of charge. The second component of the charge is talk about joinder of charges. And I said the joinder of charges are of two categories. When different persons can be charged together, when different offenses can be charged together. Let me see what the provision says. 241. Separate charges for distinct offenses. This is general rule, basic rule. So for every distinct offense of which any person is charged, there shall be a separate charge, and every such charge shall be tried separately. So for every single offenses, there will be separate charge, provided that where the accused persons by an application in writing so desire, and the magistrate is of the opinion that such person is not likely to be prejudiced thereby, the magistrate may try together all or any of the number of the charges framed against such person. So the general rule is every charge can be separate. If the accused want with more charges can be tried together, court can allow, and then it's referred to 242, 243, 244, 246. These are all about the offenses. Illustration says he is accused of the theft on one occasion and of causing grievous hurt on the another occasion. A must be separately charged and separately tried for theft and causing grievous hurt. Both are separate offenses. But if it is one go, some thief enter other person's home, he committed theft. While coming out, he found some girl and he molested her. So you have two offenses. It can be charged together in the sense that there can be two heads in which and the same trial is one go and the same trial can be conducted. Now, so general rule 241 that every single charge cases, every distinct offenses should be charged separately, tried separately. But then we started exceptions. So next section says offenses of same kind within a year may be charged together. So it says when a person is accused of more offenses than one of the same kind committed within the space of 12 months from the first to the last of such offense, whether in respect of the same persons or not, he may be charged with the tried in one trial for the number of them not exceeding 5. Now, this has been done. It does not restrict that mandatorily we have to do, but this is a permissibility. Permission is given. So a thief in last 1 year, he committed 5 theft. Why this provision has been given? The idea is, say, what happened is, say some theft is being arrested by the police, and during interrogation, it is found that he committed another 4 theft in last 6 months or 1 year. In one charge sheet, he can submit the report and he can be tried for all those offenses for a 1 year. But it will be of the same 1 year's time, have the same kind. That is necessary. So same kind is important here. 2. Offenses are of same kind when they are punishable with the same amount of punishment under the same section of Bhartiya Nagarik Sanhita or special laws, etc. Provided that for the purpose of this section, an offence punishable under subsection 2 of 303 of BNS shall be deemed to be offence of the same kind, offence punishable under 305 of the said Sanhita. So some offences can be considered as a same offences. So X was state of Kerala, section 219 CRPC only directory in nature. It's not mandatory. So because the idea is, the general rule is that every single offense should be tried separately. Every trial cases have to be tried separately. Now 243, trial of more offenses than one. So if the more offenses than one there, then how to deal with? So 1, if in one series of acts so connected together as to part of same transaction, more offenses than one are committed by the same person. I given you just example little ago. Now, to understand this word part of same transaction, you need to refer to Bhartiya Saksha Adhiniyam. Earlier, it was section 6. In the new act, BSA, it is in the Indian Evidence Act, it was section 6. In Bhartiya Saksha Adhiniyam, it is section 4. So, anything which considers the part of same transaction, at one go, the person has committed the offenses. Accordingly, for all those offenses, he should be charged at one place and tried at one place. So someone's enter some places, trespass, then theft, uh, then maybe molestations, then maybe grievous hurt or simple hurt. So there could be many things happening in one go and then persons being arrested. So for all these offenses at one go the person has committed, he can be charged for all those offenses and he will face the trial. Clause 2 says, when a person charged with one or more offenses of criminal breach of trust or dishonest misappropriations of property as provided in subsection 2 of 235 or in subsection 1 of 242 is accused of committing for the purpose of facilitating or counseling the commission of that offense, or those offenses, one or more offenses of falsification of accounts, he may be charged and tried at one trial for every such offenses. They're all related offenses. And accordingly, for all related offenses, he can be charged together and tried together. 3. If the alleged act constitute an offense falling within two or more separate definitions of the act of Nyaya Sanhita, etc., the persons of them may be charged with and tried for one at one trial for each of such offenses. You will find many places when the FIR is registered, so say child sexual abuse cases. FIR also registered in IPC, now Nyaya Sanhita, as well as POCSO. Same act, two sections, two clauses are used. They can try together. Clause 4. If several acts of which one or more than one would be itself or themselves constitute an offense, constitute when combined a different offense, the person accused of them may be charged with and tried at one trial for the offense constituted by such act when combined and for any offense constituted by anyone or more of such act. So there are many offenses which are of the same categories, where something added it become higher offense, something not there it become lesser offenses. Now there the persons can be tried together. So that's basically the provisions on the charge. It has given a large number of illustrations to explain when different offenses can be charged together or when different persons can be charged together. So B, a commit housebreaking by day with intent to commit rape. So housebreaking is an offense. He entered the home. It can be trespass also. And commit in the house to enter rape with B's wife. So of two offenses. A is separately charged with and convicted of offence under 64 and section 3 of 381 of the Bhartiya Nagarik Suraksha Sanhita. So two sections where they can charge together and they can be tried. A has in his possession several seals, knowing them to be counterfeit and intending to be used them for the purpose of committing several forgeries punishable under 337 of BNSS. A may be separately charged with and convicted of the possession of each seal under subsection 2 of 341 of Nyaya Sanhita. So these are large number of illustrations are given there. Illustration F. A with six other commit the offense of writing, grievous hurt, assaulting a public servant, endeavoring in discharge of the duty. He may be separately charged with and convicted of offenses. All those separate charge will be their different head, and then he can convicted in one trial. So there's a possibility. So there are many such cases where a persons can be tried in one trial. They can be convicted for different offenses. There are other illustrations also. We can just skip the illustrations for constraints of time. Now 244 talking about what will happen when it is not clear which offense committed. So 244 says if a single or series of the act is of such a nature that is doubtful which of the several offense the fact which can be proved will constitute, the accused may be charged with having committed all or any of the offenses, and any number of such charges may be tried at once, or he may be charged in alternative with the having committed someone of the said offenses. So give you example. Suppose someone has committed offenses of murder, but court is not sure whether it's a murder or it's a culpable homicide not amounting to murder. What court can do? Court can make charge that you and such day you have committed this murder against those persons, etc. All those details. Alternatively, you on such and such day committed this act amounted to culpable homicide not amounting to murder. So this can also possible under the law. If in such a case the accused is charged with one offense and they appear in evidence that he committed a different offense for which he might have been charged under provision of subsection 1, he may be convicted of the offense which is shown to have been committed although he was not charged with. That possible. Again, the illustration which tried to explain what this charge provision is. So, first illustration says A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. He may be charged with theft, receiving stolen property, criminal breach of trust and cheating, or he may be charged with having committed theft or receiving stolen property or criminal breach of trust or cheating. These are all alternatives. In a case mentioned, A is only charged with theft. It appeared that they committed the theft of a criminal breach of trust or that receiving stolen goods. He may be convicted of criminal breach of trust or receiving stolen goods, as the case may be, though he was not charged with such offenses. So alternative charge can be there. C. A states on oath before the magistrate that he saw B hit C with club. Before the session court, A state on oath that B never hit C. A may be charged in the alternative and convicted if intentionally giving false evidence, although he cannot be proved which of these contradictory statement was false. 245. When offense proved included in the offense charge. Now, this is another circumstances. Many times, Say someone is charged for offense of rape, but from all the evidence says it's only proof that there was an attempt to rape. So attempt including the rape definition. So a person's the charge is framed for rape, but not attempt to rape. He can be convicted for lesser offenses. A person is framed charge for murder, but ultimately from evidence it is found that he is a guilty of culpable homicide not amounting to murder. The charge was framed for murder. Now, because this culpable homicide is including participants, smaller offense in the charge. So 245 says, when a person is charged with an offense consisting of several particulars, a combination of some only of which constitute a complete minor offense, and such combination is proved, but the remaining particular are not proved, he may be convicted of the minor offense, though he was not charged with it. So, person was charged for higher offenses, proof minor offenses. Without even framing the charge, a person can be convicted for those minor offenses law permitted. When a person is charged with an offense and the facts are proved which reduce it to minor offense, he may be convicted of the minor offense, although he is not charged with it. When a person is charged with an offense, he may be convicted of an attempt to commit such offenses. So, person is tried for committing some offense, but the commission is not proof. Only attempt is proved. He can be convicted for attempt. 4. Nothing in this section shall be deemed to authorize the conviction of any minor offense where the conditions, requisitions for initiations of the minor offense, where the conditions for etc. So that's sanction requirement. Other requirement, if those not fulfilled, then it's difficult. So you have two illustrations are there. For example, a charge under section 3, subsection 3 of 61, 316 of BNS with criminal breach of trust in respect of property entrusted to him as a carrier. It appears that he did not commit breach of trust under subsection 2 of 316 of that Sanhita in respect of the property, but that it was not entrusted to him as a carrier. He may be convicted of a criminal breach of trust under subsection 2 of 316. So it's a big minor offenses which he can be tried. Same way, a charge under subsection 2 of 117 of BNS with causing grievous hurt. He proves that he acted on grave and sudden provocation. He may be convicted under subsection 2 of section 112 on Sanhita, because if so the lesser punishment the person who is entitled to, he can be convicted for that lesser offenses. That's what the law permit under the law. So these are the provisions which are the gender of charges. So now till now what we are discussing these till 245 was about what different offenses can be charged together. Now we come to the next part, how the different persons can be charged together. So 246, and you will find the same thing which was there in the CRPC. So the following persons may be charged and tried together, namely A, person accused of same offense committed in the course of same transaction. So if it is different persons committed same offense as part of same transaction, they can be charged together. I said the example, I given you example of terrorisms. So might be 10 people done something wrong in Kashmir. There are 50 other people who are part of the planning. All those 50, 60 people can be charged together. So different persons can be charged together because if they are part of the same transaction. And to understand part of same transactions, I said you need to look at section 4 of Sakshu Adhiniyam. B. Person accused of an offense and the accused of abatement of or attempt to commit such offense. So the person who is accused, he can also be tried along with the person who is accused of abatement or attempt. C. Person accused of more than one offense of the same kind within the meaning of 242. committed by them jointly with the period of 12 months. So what 242 says, in 1 year, subject to maximum 5 offenses if they have committed. So different people committed those offenses. They can be charged together. Person accused of different offenses committed in the course of the same transactions. The person accused of an offense which include theft, extortion, cheating, or criminal misappropriations. If person accused of the offense under subsection 2(5) of 317 or either these sections in respect of stolen property, theft of property, someone the receiver of stolen property, they all can be tried together. Person accused of any offense under chapter 10 of BNS relating to counterfeit coins, etc. Someone did it business, someone a carrier, someone has a receiver, etc. So these sections, it was earlier 223. These sections talking about when the different persons can charge together. So state versus Kalyan Singh, it's a Babri Masjid judgment, where Supreme Court says in demolition of Babri Masjid, discharge of some accused while proceeding against the remaining accused who were actual perpetrators of a crime in a joint trial not proper. Proceeding restore against the discharge, instigator, accused person, as all offences were committed in course of same transaction and the accomplice and joint conspiracy, criminal conspiracy direction issued for conduct of joint trial. 247, it was earlier 224 earlier. So withdrawal of the remaining charges on convictions on one of several offences. Suppose against someone, 4 charges are being made, 4 sections being used. And after trial, only 1 section found, he was found guilty. What happened then? At the time of conviction, the remaining charges court will withdraw. So there is a process in which they do under this section. So when a charge containing more head than one is framed against the same person, and when a conviction has been had on one or more of them, the complainant or the other officers conducting the prosecution may, with the consent of the court, withdraw the remaining charge or charges, or the court of its own accord may stay the inquiry into or trial of such charges or charges, and such withdrawal shall have the effect of an acquittal on such charge or charges unless the convictions be set aside, in which case the said court may proceed. This is normally happen in practice when there is someone charge being framed 3-4 charges. So person is convicting on 2 charges, then the remaining charges are being withdrawn. Okay, so when we, as I said, why we require this charge? Charge basically is required that a serious case says charge should be reduced in writing with precision and clarity. The information must be to the extent that accused shall able to understand the accusation. Charge should be then read over to the accused. That's the basic process. So accused must be aware of what are the allegations against them, what really the offense is being committed for which he is being tried. Now, framing of the charge on prima facie grounds. One of the issue arises when court frame the charge. What evidence required? You don't have much evidence at that point of time. It is the only the police would have submitted charge sheet. Those materials are there before the court. So court frame the charge on the basis of prima facie evidence. So prima facie, whatever the evidences are available against which the court frame the charge. You don't require more than that. This is not the beyond reasonable doubt issues. Here only to frame the charge that whatever the materials collected by the police, the 180 statement, earlier it was 161 statement, or earlier 164 statement, now 183 statement. All those evidences what they collected, is the court is prima facie satisfied that prima facie there is evidences against the accused, the court can frame the charge. Frame the charge, probative value of the statement of the witness cannot be gone into because you don't know the kinds of a statement which police has recorded. The same persons might not give evidence in the same way. The same persons might not turn hostile. So we don't know the probative value, because probative value will come only when those persons give evidence in the court whose statements were recorded either under 180 or 183 of the BNSS. So which could come to be decided in the close of the trial. So probative value can only be on that point of time. Now this is very important thing. Remember this case always. So State Anti-Corruption Bureau Hyderabad versus P. Surya. There are other cases also. So the issue arises at the time of framing the charge, where the court is required to consider only police report and documents submitted on 173. Now, accused has a right of being heard, and the court may examine him if it thinks necessary. However, court not justified to looking into the document filed by the accused to conclude that offense was committed. Remember, when court frames the charge on the basis of prima facie evidences. Now, this prima facie evidences comes from the police report, the charge sheet was submitted by the police. Now, at that stage, suppose someone is accused and who appear in the court and said, look, I am innocent, I have enough evidence, I will prove my innocence. Will court allow them to give evidence at this stage? Answer is no. Why no? Then at the charge, there will be mini trial. Now, we cannot convert charge into mini trial. It is only on the primacy of prima facie evidences. So, prima facie, whatever the evidence are available, if the accused want to give some evidence, that there cannot be a trial. So, from that, court can decide whether to frame the charge or not. Now, there can be other circumstances. Submissions of document to consider the framing of the charge. So, that's what I said. So, this is a very important case again. Devendranath Padhi, State of Odisha versus Devendranath Padhi. So, issue arises. Accused say, I have enough evidence to prove my innocence. At the stage of charge, he want to give evidences. That's not permissible. So, the court says, at the stage of framing of the charge, roving and fishing inquiry is impermissible. If the contention of the accused is accepted, there would be a mini trial at the stage of framing of the charge. This would defeat the object of the court. So, the charge is being framed on the prima facie evidences collected by the police under 180, etc., or 183, the statement recorded by the magistrate or other evidence which is being collected. But this will not convert, charge stage will not convert into mini trial. You don't is allowed to give evidences for against that. What material to be considered as a framing of the charge? As I said already, it is based on prima facie evidences. So, court says at this stage, court is required to evaluate the material and document on record with a view to finding out if the fact emerging therefrom, taken at their face value, disclose the existence of all the ingredient constituting the alleged offense. The court may, for the limited purpose, sift the evidence as it cannot be expected even at that initial stage to accept all that the prosecution stage as gospel truth, even if it is opposed to common sense or the broad probabilities of the case. So we don't require to look into much detail there. It is always on the prima facie evidences what is being submitted. On that only the court will decide about the charge. What will happen if there is a defect in the charge? Now remember, whether it is a material defect or not, those are the things always play important role. So this is the case about Dowry Prohibition Act, and court acquitted the accused. Acquittal order was challenged by the complainant in the High Court. Now, the High Court set aside the order of acquittal and sent for retrial on the ground that there was defect in framing of the charge, inasmuch as it has been noticed that one of set of the charges does not contain the signature. Further observing that when a female is an accused, it is impossible to say that she had been made aware of the charges leveled against her. The other defect mentioned is that one of the charges, the section has not been mentioned and therefore the charge has not been properly framed. Supreme Court observed that in this case there was no grievance about prejudice having been caused on the account of non-framing of the proper charge is made by the accused. There is no ground for direct retrial. So whole idea was that whether this mistake or omission in the framing of the charge resulted in some kinds of uh, prejudice to the accused persons, their understanding what offense being committed or not. If the answer is yes, then only it is material, otherwise not material. So that's basically the framing of the charge. Now we'll come to our next topic, which is on trial part. Now I said there's a four kinds of a trial: session trial, warrant trial, summon trial, summary trial. So we'll start with session trial. So now we start with criminal trial. Now again, very important topic. In fact, every single cases go for trial. Now the which cases will go for session trial, which cases will go for other trial. From where we'll find it? You will find this in the first schedule of BNSS. Earlier it was first schedule of CRPC, where you will find in the last column in it is in respect of the IPC offences which trial will be conducted, whether it's a session trial or trial by magistrate. That you will find in the last column. When Arif says 2 years term, it is true. Rape case, murder case, punishment is more than 2 years, and they go for session trial. But 2 years term is mentioned in respect of warrant cases. So the cases which are warrant cases, where that means the punishment is more than 2 years, those are all warrant cases. Where the punishment is up to 2 years, they are summon cases. So summon cases go for summon trial and summary trial. Warrant cases go for warrant trial or session trial. In some of the warrant trial where this is specifically mentioned in the act, it might go for summary trial. That's the exception. But the general rule is all warrant trial can go for either, warrant cases will go for either warrant trial or session trial. Which are the warrant cases? Warrant cases are where punishment is more than 2 years. Where the punishment is up to 2 years, they are summon cases. Summon cases go for either summon trial or summary trial. Now, session trial being the highest in nature, all the serious cases goes for session trial. So, almost all serious cases, the trial conducted are the session trial. So, let we see the provisions relating to session trial, and that's what we are discussing now. So, if we look at the CRPC, it was from 225 to 237. That's the broad sections in which the process of session trial laid down. While in BNSS, the same thing is from 248 to 260. They talk about session trial. So, that's the basically legal framework which talk about the session trial, the manner in which the session trial being conducted. So, when a session trial is conducted, it is conducted by a session judge. So, it's a district level court. So, one session judge is there. There are additional session judge. Remember earlier there was another court called assistant session judge. In the BNSS, that concept gone. So, we don't have any assistant session judge. So, the trials are either conducted by session judge or additional session judge, where they can conduct the session trial. So, the first sections 248. Now, these are all procedural in nature. So, my idea is just to explain you the process or procedure in which these trials are being conducted. So, first thing 248 says, who conduct the session trial? Public prosecutor. So, in every trial before a court of session, the prosecution shall be conducted by public prosecutor. Now, when we use the word public prosecutor, it's include special public prosecutor. Also, the public prosecutor appointed by the state government, public prosecutor appointed by the central government. What it does not include is assistant public prosecutor. So, assistant public prosecutor normally practice in the magistrate court. So, in every trial before the court of session, who conduct? Public prosecutor. That's the first thing. Then the next section says opening of prosecutions. So when the accused is appear or brought before the court, remember how the cases go to court of session? We discussed in the last class that say for example, this is a rape case. In a rape case, police submitted charge sheet. So when the police submitted charge sheet, suppose it was in CRPC, then 173 CRPC. If it is under the BNSS, 193 BNSS. Once the charge sheet is submitted, then on that charge sheet, court can take cognizance. Under the BNSS, under 210, court can take cognizance. Once the court take cognizance and the case is session triable, rape case, magistrate cannot conduct trial. So the CGM or ACGM has taken cognizance of rape case under 210. So what they will do after taking cognizance, they will see some compliance is being made or not of delivery of the copy, etc. So those compliance they will ensure. And once those compliance are there, the session magistrate court assistant says assistant ACGM or CGM, so Chief Judicial Magistrate or Additional Chief Judicial Magistrate, they will transfer the case to Court of Session. So when the case is transferred to Court of Session, and that's what is referred to when the accused appear or brought before the court in pursuant to commitment of the case under 233. So under 233, the CGM or ACGM has transferred the case to Court of Session or under any other law for the time being in force. When it says about the under any other law for the time being in force, that means there might be some special laws. You have NDPS, you have Essential Commodities Act, POXO Act, where there is a special code or the cases goes to session court level. The prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposed to prove the guilt of the accused. So who start this case? The case is started by the public prosecutor. The public prosecutor will bring the all evidence, say that okay, these are the things against the accused persons and how he proposed to prove the guilt against the accused persons. Remember at this stage, because this is the stage of framing of the charge, still charge is not framed. Thus PP started. At this stage, accused may also submit application for discharge. When discharge happened? Discharge always happened before framing of the charge. Once the charge is framed, there is no question of discharge. Then either acquittal or conviction. So before framing of the charge, accused may submit application for discharge. And now under the BNSS, they have laid down the timeline that within 60 days, they have to submit the application for discharge, etc. So some timelines are given there. So the any prosecutions or session trial, it starts with public prosecutor. So public prosecutor bring available and the accused need to be prosecuted, etc. and charge it to framed. Then next section says charge, discharge 250. Now it's not that the court actually automatically discharge. It's normally accused submit application for discharge. So accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under 232. So when a case is committed to the court of session, within 60 days, accused may submit an application for discharge. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considered that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reason for so doing. So the accused can be discharged. If there are no materials available, then an accused can file application for discharge. There will be hearing. Court will hear both the side, prosecutor side, the accused side. And then if court finds there is no no materials to proceed against the accused persons, etc., then in those circumstances, what the court can do? Court can discharge the accused person. Then what happened? So that's the process. But if not discharged, then the next section. So, here in ME, this case, 250, 251, 252, 253, 254, 255, 256, 257, 258, 259, 260, 261, 262, 263, 264, 265, 266, 267, 268, 269, 270, 271, 272, 273, 274, 275, 276, 277, 278, 279, 280, 281, 282, 283, 284, 285, 286, 287, 288, 289, 290, 291, 292, 293, 294, 295, 296, 297, 298, 299, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 211, 212, 213, 214, 215, 216, 217, 218, 219, 220, 221, 222, 223, 224, 225, 226, 227, 228, 229, 230, 231, 232, 233, 234, 235, 236, 237, 238, 239, 240, 241, 2 Shiva Linga Murthy versus CBI, expression the record of the case occurring 227 means the document and articles produced by the prosecution, because remember the charge is framed on the prima facie evidence. Prima facie, whatever the materials are produced, that's what they're taken into account. Union of India versus Prafulla Kumar Samal. So with sufficient ground for proceeding, special judge power to pass order for discharge. So when there is not sufficient ground to proceed, there is no materials evidence, says the court has power to discharge. So accordingly, court says special should not act as a trial judge, but should weigh evidence and forms opinion only on the limited questions of whether a prima facie case made out, excepting the cases of grave suspicions which the accused is unable to explain. He is empowered to discharge the accused. So if the court thinks that not sufficient materials are available, no point in proceeding with the accused, unnecessarily wasting the court time, court has a liberty to discharge the accused. That's possible under the law. And that's what the court says. Now, if the discharge is not there, so the prosecution start, then the discharge application, court did not discharge. Then the next stage goes of framing of the charge. So what we discussed in the charge provision, now the court will frame the charge. So what this section says, it says if after such consideration and hearing as aforesaid, the judge is the opinion that there is a ground for presuming that the accused has committed an offense. So when court thinks that there is a prima facie evidence is available against the accused must have committed the offences, etc. And then A, it is not exclusively triable by court of session. He may frame the charge against the accused and by order transfer the case for trial to CGM or any other judicial magistrate. So even if that stage, session court thinks that no, it is not session triable case, it is magistrate triable case. So the session judge may frame the charge and then send back to CGM or ACGM, etc. B, is exclusively trial by the court. He may frame in writing charge against the accused within the period of 60 days from the first hearing on the charge. Now, this is the new inclusion. The timeline was not given in the old law in the CRPC. So now, if the court thinks there is a materials to proceed against the accused, court shall frame the charge against the accused person within 60 days. That's the timeline given. Number 2, where the judge frame any charge under clause B of subsection 1, the charge shall read and explain to the accused present either physically or through audio, video, electronic means, and the accused shall be asked whether he plead guilty of the offense charge or claim to be tried. So now, after framing the charge will be read over to the accused. Accused will be asked whether he is accepting guilt or he want to be tried. Now, suppose if the accused of guilt, then court has a power to convict. So in State of Delhi versus Bansal case, court says principle is summarizes the principle of the requirement and duties of the court at the stage of framing the charge. Remember, the framing of charge is always on prima facie evidences. So there must be appreciation of materials available on record at the stage of framing of the charge. Grave suspicion is enough for framing the charge because it's a prima facie evidence. You don't require full proof beyond reasonable doubt at that point of time. There is no scope of framing of the issues in a criminal trial. It is solely in the realm of civil matters. So issues, etc., are framed in the civil cases, not in the criminal cases. Now, so accused has been read over the charge. Next section says 252. If the accused plead guilty, then what the court will do? So if the accused plead guilty, the judge shall record the plea and may in his discretion convict him thereon. Why the word may is here? He could have been mandatory, shall convict, it could have said. So if the accused is pleading guilty, he say I am guilty. It could have said court shall convict him, but why they use says shall record the plea? So court will write whatever he said and may in his discretion convict. guilty pleading, or we call it admission or confession. So it's admission, he admitting that guilt. There's a two basic test. Court has to satisfy itself that that guilty pleading is voluntarily. Two, court has to satisfy itself that guilty pleading is really truth. So the truthfulness, voluntariness, these two tests are essential for accepting any admission. He might pleading guilty just to save his girlfriend or his wife or his brother. That's possible. So the court has to satisfy that really the person is pleading guilty, it is voluntarily and truth is a true matter. Then court can file him. That's why it's may. So court is a discretion. So many times what the court do is, instead of convicting immediately, court may take one or two witnesses, and once the court is satisfied that what he's saying is true, what he's saying is voluntarily, the court can convict. But law permit, if the court is satisfied under 252, if the accused is pleading guilty, he can be convicted. So there is no requirement of further going for any trial. And that's the principle of evidence law, which is now Bhartiya Saksha Adhiniyam. So general principle is fact admitted need not be proved. So if someone is admitting guilty, court can convict under 252. Now, but if he's not pleading guilty, then the questions of trial comes. So next section comes 253, date for prosecution's evidences. So if someone is not plead guilty, that means he wanted to face trial, then the court will fix the date for examinations of the witnesses. So prosecution evidences. So criminal cases always start with prosecution witnesses. So the trial will begin, prosecution evidence will be conducted. So the accused refuses to plead or does not plead or claim to be tried or is not convicted, the judge shall fix a date for examination of witnesses and may, on the application of the prosecution, issue any process for the compelling the attendance of any witnesses or the production of any document or thing. So court can call for all those witnesses. So normally what happened in the trial, at this stage, suppose in the charge sheet there are 20 witness names are there. The prosecution make a schedule at least 4 or 5 days or a week time, that every day 2 witnesses will be examined. So 7 days he examined 14 witnesses. And so in session trial, normally a schedule is being prepared and day-to-day trial being carried out. That's what happened in practice. So the prosecution date will start. So prosecution will give all witnesses. All prosecution witnesses will be, say, examinations. It will be examination in chief. It will be cross-examination, re-examination. All things goes together, subject to some exception in some cases. There might be re-examination, cross-examination later on, but as a general rule, it go together. First examination in chief, cross-examination, re-examination. So first prosecution will give all witnesses. What will happen next? So under 254, evidence of prosecution. So on the date so fixed, judge shall proceed to take all the evidences as may be produced in support of the prosecution. Some witnesses examination may be conducted by audio, video, electronic means. The depositions of evidence of public servant may be taken through audio, video, electronic means. It was also not there earlier. Judge may in his discretion permit the cross-examination of witnesses be deferred until any other witness are examined. So there might be some exceptional cases where, say, witness number PW2, witness number 2 appear, and the sum of the his examination chief is done, and the defense lawyer thinks that it is better to cross-examine him after the examination of PW4, because there's some relations are there. Then the defense lawyer can submit an applications, and that comes under clause 3. He may ask the judge that, look, I want to cross-examine him only after examination of PW4. So his cross-examination may be deferred, and once that examination will be done, and thereafter cross-examination will be conducted. So that may be possible that in some cases the cross-examination will be conducted later. But as a general rule, examination in chief, cross-examination, re-examination, all these go simultaneously. But under clause 3, judge may in his discretion permit the cross-examination of any witness to be deferred until any other witness or witnesses have been examined, or recall any witnesses for further cross-examination. Now, these are the issues of discretion of the court, power of the court. So, State of Kerala versus Rashid 2019 judgment, and Supreme Court said it was in CRPC 231-2. So, it says the 231-2 confer a discretion on the judge to defer cross-examination of any witness until any other witness or witnesses have been examined, or recall any witness for further cross-examination in appropriate cases. There cannot be any straitjacket formula providing for grounds on which judicial discretion under 231 CRPC can be exercised. Guiding principles and factors to be kept in consideration while deciding application under 231-2. So, this case in detail discuss about what the circumstances. It says there might be some justifiable reasons that a defense lawyers want to examine this witness after X witness examination. Possible. And we have a fair trial principles warrant that we must give reasonable opportunity to defense to defend their cases, and accordingly they allow these kinds of deferment of cross examination. It's possible, it do happen frequently. Now examination is conducted of all the prosecution witness. So there were 10, 12, 15, 16, 20 prosecution witnesses, and their examination is conducted. Then what will happen? 255 says acquittal. So all the prosecution witnesses are being examined, and if after taking evidences for the prosecution, examining the accused, hearing the prosecution. Now, when we say examining the accused, it is basically earlier it was 313. Now number has changed. So it's 333 or 332, somewhere nearby. You'll find that provisions where the witnesses. So prosecution is examinations and the defense on the point. The judge considered that there is no evidence that the accused committed the offense. Judge shall record an order of acquittal. So what the court will do? Court will acquit the accused. 255 acquittal. It was earlier 232. But if the court is not acquitting, then again you have give accused the opportunity as a fair trial principle that he can bring own witnesses. So there the questions come under 256. Now the defense will enter. So the defense will start giving witnesses. So entering upon defense, and it says where the accused is not acquitted under 255, what he will do? He shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. So if the accused want to give some witnesses, the accused want to give some evidences, then the accused has right to bring his own witnesses. If the accused puts any written statement, the judge shall file with the record. So there are many circumstances when accused put written statement. But one thing remember, accused is not a witness. So accused does not automatically become witness. There's a separate procedure for accused to become witness. We'll discuss in the subsequent class when we talk about evidence recording, etc. there. So there's a process in which the accused can become witnesses, but accused can call his witnesses. Because remember, the accused has a right to silence. But if the accused become witnesses, then he will be subject to cross-examination, though his right will go. So there is a check that accused, if really want, that he must submit applications and the process through which he can become witnesses. Clause 3 says, if the accused applies for the issue of any process for compelling the attendance of any witness or for the production of any document or things, the judge shall issue such process unless he consider for the reasons to be recorded that such application should be refused on the ground that it is made for the purpose of vexation or delay or for defending the end of justice. So the court can pass order for calling those witnesses. Court can pass order for bringing those documents, that also possible. Now, once the accused witness is over, then what's the next step? The next step is argument. So now the prosecution witness is over. Then you have done examination of accused, everything. If the accused is acquitted, then nothing arises, defense things. But if the accused, there's a prima facie evidence are available against the accused, then court shall ask the accused if you want to bring some witnesses. If the accused want to give witnesses, then their witness examinations. In the same way, their examination in chief, cross-examination, re-examination, same principle apply. And once this accused examination is over, the next step is argument. What it says, when an examination of witnesses, if any, for the defense is complete, the prosecution shall sum up his case and accused on his advocate shall entitled to reply. So prosecution will sum up the case and accused can give reply, provided that where any point of law is raised by the accused or his advocate, the prosecution may, with the permission of the judge, make his submission with regard to such point of law. So, if the accused has raised some legal issues, then the prosecution will give reply as to those legal issues. Now, that is all done. So, both side witness examination is done, argument is done, there can be written argument also, this is all done. Now, the time comes for judgment. Judgment of acquittal or conviction. So after hearing argument and point of law, if any, the judge shall give a judgment in the case as soon as possible within a period of 30 days. Now, this was not there earlier. Now they have added it. So within 30 days from the date of completion of argument, the court has to give judgment. We have seen many cases where the judgment take much longer time, just waiting for judgment. Court need to give judgment. Now judgment is not coming. Now the law is very clear. The judgment has to be given within 30 days from the date of the completion of argument, which may be extended to a period of 45 days for the reasons to be recorded in writing. So if the 30 days need to be extended to 45 days, the reason need to be given there. Now, one very interesting thing, it was earlier 235 and 235 clause 2 is very important. You must have seen many cases in reality where court pass order for conviction one day, but do not give sentence. Have you seen any cases where court pass the order today and conviction, they give sentence same day? I said, no, you will not find it. So court finds someone guilty on one day, and then comes 235, 258 clause 2, which was earlier 235 clause 2. What is that? It is sentence hearing. This is a mandatory process. And accordingly, what normally court do is, if the court is finding someone guilty, court can find him guilty. And then the court will fix a date for hearing under clause 2. So what the clause 2 says? If the accused is convicted, the judge shall, unless he proceed in accordance with the provision of 401, etc. Those are basically when court want to give probations, etc. So if the court is not giving probations, etc., then essential requirement, hear the accused on the question of sentence and then pass sentence on him according to law. This process of sentence hearing is mandatory. So after finding someone guilty, court cannot pass sentence immediately. So court gives some time. We call it reflection of time. So maybe 1 week or so, or 10 days or 5 days. And then the again accused is called for sentence. So there is a sentence hearing in between. Why we have this? The reason being that before this point of time, accused was fighting the case. He was a fighter. He was claiming he's innocent. He is bringing his evidences. He put all the effort that he can be established innocence. But now all those fight is over. Now he's found guilty. Now the only issue is how much punishment. Under our law, most of the places you will find the punishment used to be punishable up to 10 years, punishable up to 5 years. What does that mean? It can be 1 day, it can be 5 years. It can be 1 day, it can be 10 years. punishable up to 20 years. It can be 1 day, it can be 20 years. So there's a huge margin available with the court. How the court will exercise that margin? What will be the just punishment for the accused or even to victims, etc.? The process are sentence hearing. So now the accused will bring all those materials on record to show mitigating circumstances. What could be the mitigating circumstances? Accused might say that if he go to jail, his wife, his children, his parents, they will be suffered. So it will be punishment for 6 people. They may die with hunger. These are all mitigating circumstances. On the other side, the prosecutor will bring evidences which are aggravating circumstances. He may bring evidences about the heinousness of the crime, impact on the society, why he deserves higher punishment. So the one side, the prosecutor will give some circumstances which are aggravating in nature, asking for higher punishment. Accused will give evidences or some argument that he deserves some lesser punishment, leniency from the court. And then ultimately court will decide whatever the punishment courts will give. But this is a major essential requirement. Now, interestingly, now many jurisprudence has been developed which we call victim impact assessment. So there are few high court judgment, Delhi High Court and others, where they say the court must look into the impact of the offense on the victims. When they brought this law, they could have incorporated in these provisions, but which they have not done. So victim impact assessment somewhere is a due. So that's the 258 has talking about under this clause 2. It's a mandatory process for sentence hearing. Without this mandatory process, the sentence cannot be given to any accused. So Ramesh Bhai case, court says pre-sentence hearing, principle of natural justice while recording of a special reasons for imposition of death sentence must be followed. Right of the accused and duties of the court says what are their duties. Proportional principles of fairness, reasonableness and justness, court has again discussed. So purpose of adding such provision in recognition of new trend and penology and awarding of sentence taking into consideration various factors. It is a humanist principle of individualizing punishment to suit each accused person and his circumstances. Yaqub Menon case, we know he was given death penalty. So the whether a case fall within the rarest of the rare cases, whether the person deserve higher punishment, whether the punishment should be more or not, these are all aggravating and mitigating circumstances can only be proved when those materials, those facts are brought before the court, otherwise not. Now 259 says about the previous convictions. In some cases, when accused is got convicted earlier, then remember on many circumstances, the accused deserve higher punishment, because many times it says in the second offense, the person will punishable like this. So there's a higher punishment. Then in those cases, that also need to be mentioned that the second offenses are there. So 259 says, in cases where previous conviction is charged under the provision of subsection 7 up to 34, and the accused does not admit that he has been previously convicted as alleged in the charge, the judge may, after his convicted the said accused on 252 or 258, take evidence in respect of the alleged previous conviction and shall record in finding thereon, provided that no such charge shall be read, no such charge shall be read out by the judge, nor shall be accused be asked to plead thereto, nor shall be previous convictions be referred to by the prosecution or in any evidences adduced by it, unless and until the accused has been convicted under 252 or 258. So when there are convictions, then it can be only brought in. 260. 260 says, procedure in cases instituted under subsection 2 of 222. Now remember, I said these are sections which basically the special provisions in respect of under 222, the Court of Session taking cognizance of the offence under subsection 222 shall try the case in accordance with the procedure of trial of warrant cases. Now, this case does not happen. So, we have discussed in the last class defamations to the president, governor, etc., etc. Those circumstances are there. So it does not happen to that extent. We don't find much stages. In many places, I already seen many places, there's a timeline is being fixed. So discharge application, we have seen 60 days time, framing of the charge, 60 days time. Accused can give a statement or plead by audio, video, electronic means. Examination of witnesses through audio, video means that also possible under the law. Okay, that's